The police did not read me my Miranda rights. My case gets dismissed, right? Today is not a good news day. Hi, my name's Dale Savage and I'm a criminal defense attorney here in Charleston, South Carolina. And today we're talking about what happens when police do not read you your Miranda rights. First and foremost, if police fail to read your Miranda warnings, it is not an automatic dismissal of your case. Let's talk about the language of Miranda and what's actually said. Number one, you have the right to remain silent. That's right, the very first thing that comes out of a police officer's mouth in the state of South Carolina when they read your Miranda warnings is that they're telling you you have the right to remain silent. That means they're asking you or telling you that you don't have to talk to them. And for the love of God, take them up on that offer. Do not talk to the police. You are not going to talk yourself out of that situation. And as you'll see from the rest of the warnings, it's not good for you. Number two, anything you say can and will be used against you in a court of law. That's why you accept their offer on number one. You have the right to talk to a lawyer and have him or her present with you when you talk to police. If you cannot afford a lawyer, one will be appointed for you. If you make a statement or answer any questions, you can stop at any time you choose to. Typically, if this is a situation you're in, it's too late, and that's why you need to follow number one. Let's talk about what Miranda warnings actually are. Miranda warnings are a legal requirement that you are entitled to when you are subject to police custodial interrogation. And let's break that down. Custody means that you are not free to leave, you're in police custody. You cannot walk away and leave the situation. And the second one is questioning by police. And what's important with Miranda is that both of these issues have to be present, meaning that you have to be in custody and subject to police interrogation. If you're only in one of those situations, then you're not entitled to your Miranda warnings. And let's talk about how that may happen. If you're walking down the street, for example, and you see police and they just start talking to you, and you can walk away from that situation, but you get nervous, you panic, or you feel like you just need to get something off your chest, and you tell police, I've got to be honest with you, I've got 5 pounds of weed in my backpack right now. Guess what? That statement and the evidence obtained from that statement is going to come against you or come into court against you in trial. The second scenario is if you've already been arrested and you're going through the booking process and you were asked information such as your name, date of birth, social security number, and address. That is not what our courts have deemed to be custodial interrogation, because they're not questioning about information to a crime. So let's talk about what happens when police do violate your Fifth Amendment rights. Our courts have said that the legal remedy for such a violation is suppression of the statement and any evidence gathered from that. And the reason for this is our courts have said because it's a constitutional right, they're going to enforce a strict reading of that and do what they can to deter police from violating your rights. And in this case, that means any evidence obtained from that violation is inadmissible against you. Now, what's important to understand in this situation is it doesn't mean that all the evidence in the case is inadmissible against you. For example, if police have other physical evidence or circumstantial evidence that's not tied to that Miranda violation, that can and will still be used against you, and they can still prove that case. So, if you have any questions regarding your arrest and any possible Miranda violations, please give me a call at 843-530-7813. I hope this video was helpful, and thanks for watching.